Welcome everyone to today's presentation. I'm glad you could join us. My name's Kimball Norup. I'm the CEO of ComplianceHR. I'll be your host for today's webinar on navigating through the chaos of independent contracting compliance. On behalf of Littler, our corporate JV partner, and the entire ComplianceHR team, I want to thank you for sharing some of your valuable time with us today. For those of you who aren't familiar with ComplianceHR and perhaps aren't clients yet, we have a variety of solutions designed with content and best practices from the employment law experts at Littler to assist you in complying with wage and hour, paid leave, COVID, and other vital employment requirements. Today, I want to direct your attention to our independent contractor app, which can help you navigate through the chaos that is independent contracting compliance. We hope that today's presentation will inspire you to want to learn more about the Navigator Suite and how it might be valuable to your business. At any time during the webinar, you can easily request a demo by clicking on the hyperlink URL in the links panel of the web interface that you see in front of you. We've also included this URL in the footer of each slide, which, by the way, we will be sending you the complete slide deck after the presentation. Finally, if you prefer assistance with a demo registration, just use the chat Q&A box that you see to your right there to share your email and perhaps a best phone number. In either case, I can promise a short, non-salesy demo, after which you can decide if our products can improve HR compliance at your organization and hopefully make your life a little easier. We have a lot to cover today. But don't worry about taking detailed notes. We'll be sending you the slides, as I mentioned, and the presentation recording. Also, I should mention that if you do see a demo, if you see a demo but want to explore on your own, we do offer a free 14-day trial. Once again, use the URL at the bottom of your screen, compliancehr.com, webinar/demo. More on that at the end of our program. We'll be happy to answer any questions you may have on either the Navigator Suite or the presentation today. If you submit questions via the Q&A box, we'll answer them as soon as we get to them. Now, I'm excited to be joined today by not one, but two incredible speakers. Before I introduce them, I want to just take a brief moment to reflect on the huge changes that the COVID-19 health crisis has had on our workforce and just the general workplace in the U.S. and across the globe. A lot of great content on this. One great study was published by MBO Partners, who calls this the Great Realization. And in their 11th annual report on the state of the independent contractor or the independent workforce in America, in 2021, millions of workers sought better work-life balance, shorter commutes, greater flexibility, and the ability to pursue their own dreams. Many baby boomers decided to retire ahead of schedule, workers quit their traditional jobs, and millions decided to join the independent workforce. In fact, we saw a 34% increase in 2021. A few stats here on the charts, a few more charts. Here are two more interesting findings. We're seeing a big change in the demographics of the independent workers, and they are workers that your company likely would love to have. 55% of the newcomers are female, and 69% are Gen Z or millennials. Both rookies and veterans to the independent workforce report that they are happier and healthier in their lives and more secure in their jobs. 63% say that working independently was entirely their own choice. Those quitting traditional jobs said they were drawn to independent work by the flexibility, autonomy, and control that it provides. So as you can see, millions of Americans want to work independently and are happier working independently. Even in the radical state of California, which is where I call home, voters think Americans should have the choice of to work as employees or as independent contractors. And with over 11 million jobs going unfilled, it seems like companies should be able to engage the growing independent workforce. Yet our state and federal governments continue to pass laws and regulations that make it more difficult for workers to make the independent contractor choice, and more challenging for companies to comply with independent contractor laws. And this is our topic today. How can you comply with the chaos of independent contractor laws and regulations? How can you engage the growing independent workforce without incurring liability for overtime, taxes, unemployment, and all the rest? To help us unpack this, I'd like to introduce you to two amazing speakers that we have on board today. First, I'm really pleased to introduce you to Tammy McCutchen. Now, she's a familiar face and voice. If you've been joining some of our webinars over the last few years, you've heard Tammy and her expertise. For those of you who aren't familiar with Tammy, Tammy was a Littler Mendelson shareholder in its Washington, D.C. office. During her amazing career, she served as the administrator of the Department of Labor's Wage and Hour Division. Many of the regulations and opinion letters that govern the topic of exempt, non-exempt, Tammy authored. She is widely considered to be one of the country's foremost experts on all things wage and hour. Closer to home, when you use Navigator IC, you're actually using what's called an expert system. And an expert system is only as good as the expert process that it emulates. In this instance, Navigator IC is the mechanical image, if you will, of Tammy's thought process. Like many, Tammy decided to semi-retire in 2021, moving to scenic Eastern Tennessee near the Smoky Mountains. But she continues to support us here at ComplianceHR as an independent contractor. Also joining us as a special guest is Maury Baskin, a shareholder in Littler's DC office and co-chair of Littler's Workplace Policy Institute, or WPI. We are very excited to have Maury with us today because he has been successfully battling with the U.S. Department of Labor for many years. In 2016, he led and won a challenge to the overtime rule that would have raised the minimum salary for exemption to over $47,000. Then he did it again this year, winning just last month a case defending the 2021 independent contractor rule. Yes, folks, he got that rule reinstated, and he is here to tell us all about this successful litigation. So with that, welcome to both you, Tammy, and I think you're ready to start us off.
I sure am, Kimball, and thank you very much for the great introduction. I want to start with some background, and then we will bring in Maury to get to the microphone to talk about the litigation and what will come next. So, folks, I thought I had done my last talk on the January 2021 independent contractor regulations. So, in my February webinar and last month at a SHRM Employment Law Conference in D.C., I reviewed the regulations briefly as a reminder before talking about how the Biden administration had withdrawn these regulations. But here's my slide again. Do you remember these regulations? Probably not, because none of us really thought we would have to comply with them. But DOL formally in these regulations adopted the economic reality test for distinguishing between an employee and an independent contractor. Now, that was not at all controversial. It has been the law in federal courts for decades. It's just that DOL did not have any regulations at all on independent contracting before this rulemaking. So here is the economic reality test there on your screen. An individual is an employee if, as a matter of economic reality, the individual is economically dependent on that employer for work. Now, the controversy for these regulations was about the factors and the analysis used to make that economic dependence determination. Different courts had adopted different factors. Some had 5 factors, others 6 factors, and the DOL had looked at 7 factors. In the regulations, the DOL adopted 2 core factors: the nature and degree of control over the work and the worker's opportunity for profit or loss. If those factors pointed in opposite directions, then DOL would look at 3 additional factors that are on your slide, and more on that substance later. But first, let's talk about what happened to these regulations. I'm betting that, like me, most of you in our audience today never really paid much attention to the regulations. After all, they were not published by the Trump administration until January 7th, 2021, less than 2 weeks before President Biden was inaugurated. and had an effective date of March 8th, so well after the Biden administration started. To no one's surprise, the regulations apparently never went into effect. Instead, the Biden administration delayed the effective date of the regulations first, and then they rescinded them. And it seemed like, to most of us, that they had followed the procedures required by the Administrative Procedures Act by first publishing a notice to delay and a final rule to delay, and then publishing a proposal to rescind the regulations, and then a final rule to rescind those regulations. Okay, folks, did you think that was it? The end of the story? Well, I sure thought that the regulation was dead. But the reports of its death and demise appear to have been a bit premature. Here to tell us all about that is the man which DOL most fears, Maury Baskin. Okay, Maury, I'm going to turn it over to you now. Tell us what happened next in your litigation.
Okay, well, thanks, Tammy, and great to be with you, especially with something successful to talk about. And it was a surprise to some, but frankly, from the get-go, when the Biden administration tried to put the freeze on the regulations, there's sort of a myth about changes of administration and that a freeze is automatic on everything the previous administration had done. But in fact, during the Trump years, even the Obama transition, there had been some court decisions that said you can't just flip a switch and turn these things off. The department had gone through detailed rulemaking, had followed all the procedures, and I'm talking about the Trump people, to issue the regulation. It had been finalized. They just had not reached the effective date. And so for the Biden people to just say that, well, we can just freeze it, and without giving adequate notice and comment, without giving adequate reasons, it did not pass the smell test to a brave coalition of folks in a number of different industries. A lot of, the Coalition for Workforce Innovation, Associated Builders and Contractors, and ultimately the Financial Services Institute. So, and within them, there are a lot of coalition partners who are, have a lot at stake with the independent contractor issue. So we filed the original challenge to the delay rule. And then after we had already filed the complaint, they just went right ahead, the Biden folks, and said, well, we've delayed it, so now we're going to withdraw it before it can ever go into effect, or so they thought. Once they withdrew it, we amended the complaint to say, you can't withdraw it. You violated the rules on the delay part, and now you're violating the rules on the withdrawal part. So bottom line, without getting further into the weeds about administrative procedure, the bottom line is we went to a federal judge who said they did it wrong, both on the delay rule and the final withdrawal. And you just got to go to the last page of the opinion, and all you care about is what she said at the end was the Trump rule was supposed to go into effect on March 8th of 2021. I hereby declare that it is in effect. So it's in effect, and their attempted delay and withdrawals are not in effect. And so now, the next question, and Tammy, we can certainly talk about it, is what does that mean as a practical matter? And by the way, she vacated their orders. So we can get into issues about nationwide aspect. But I should say, though, right before we get there, I want to make two kind of disclaimers. Number one is, keep in mind, this is only the U.S. Department of Labor, their regulation for the Fair Labor Standards Act. So we're not talking about the National Labor Relations Board treatment of independent contractors. We're not talking about the IRS treatment of it. We're not talking about the state ABC tests, although, Tammy, I'm sure you're going to touch on some of these other complications. But for the Fair Labor Standards Act, which is one of the higher stakes aspects, because you get these class action wage cases coming out of improper classifications, the Trump rule really did a positive thing, which the court recognized. They attempted to bring order out of chaos. The current state of the litigation in all the different circuits, everybody is using a different test, including the Department of Labor internally is using multiple tests. And what they did, they analyzed them all, and they said, they boiled down to these two core factors, plus the others in cases where there's doubt, and they followed the law, and they came up with a simpler way of analyzing. That's really what they did. And so there's every reason to think that it is valid. But the other disclaimer is it's obviously not over, the situation. The court decision came out in March. The government has 60 days to file an appeal. It's generally expected. Well, they haven't said one thing one way or another what they're going to do. They obviously have a choice whether to file an appeal or not. And Tammy, you wanted to interject something there?
Yeah, I do want to talk about that more. Yeah, I do want to talk about that more later, but I also wanted to pause you a little bit here and say, okay, this was in Texas, Eastern District of Texas, right? And I seem to recall going along with you, Maury, to the oral arguments for the overtime case in the same district, and I think you made me get a parking ticket because those oral arguments went on so long.
Yes, we
so
like
Texas,
the Eastern District of Texas. It's a good place to litigate, and not that you're guaranteed. In fact, the overtime case was decided by an Obama-appointed judge. And the judge who ruled in this case was appointed by Bush. So, these are not Trump judges ruling on the Trump order. And both times, all you can expect is and hope for is a fair hearing. We think, a fair decision, well reasoned, lots of case authority. She did her own exhaustive analysis. So I think the government has their work cut out for them to, if their hope is to get this overturned. And we can talk as we go here about what happened, what could possibly happen next.
So I got some things. Maury, I read the decision, and the full name and the date of the decision, folks, is on the screen in case you want to Google it and look it up and read the whole thing. So I took some of her quotes out of it, and I'd love you to comment then. So she said the rescission was arbitrary and capricious. So that's not just a procedural problem, right, Maury? It's a substantive decision.
Yeah, I mean, it does come under the Administrative Procedure Act, but it's more substantive than it means. The guts of it were actually decided correctly, and the action by Biden to his folks to withdraw it was not. It does go to substance in that way, as opposed to, say, notice and comment, not enough days left for notice. That would be more procedural in nature. Actually, she found both were in play, and so, that's good news. Again, there's more for them to overcome. And what they really failed to consider, and we hammered on this a lot, was that the Trump rule was designed to give better guidance. And their only reaction was, well, it doesn't give perfect guidance, or it doesn't get the job done. Well, her reaction was, and ours too, was, what was their alternative? Their alternative is just to leave all of you without any guidance at all. That was useful because of the way all of the courts had been going all over the map. And so that resonated with the court, and the judge basically agreed, said that by withdrawing the Trump rule and not having anything in its place, and without considering reasonable alternatives, the Department of Labor, the Biden Department of Labor, has now left the regulated parties without any consistent guidance at all. And I see a question that I could jump to because it kind of relates to it, but it's also more about what we're going to do going forward. So maybe let's hold that for just a second. But the alternatives, she lists some things they could have tried. I think they have they have their work cut out for them there, because to go through and come up with these alternatives, it undercuts their argument that nothing it should be done that's different from fact sheet number 13, or the various factors that different courts want to use. So it puts them in a hard place. Which is it? Are they saying that this is wrong or not wrong, or reasonable alternatives considered and rejected, but then why are they rejecting them? They're going to have to support that. So again, it's a positive result. There are other reasons too why she could have also gone our way, and that are still available to argue, because there were studies done by the Trump administration that showed how positive, and we saw a reference to some studies earlier, but there are many positive reasons to keep and promote independent contractor status. It's not just a bad thing, which is what the Biden people seem to their attitude to be. So there are even more reasons that have not yet been fully addressed, frankly, why the actions in withdrawing the Trump rule were wrong. So Tammy, why don't you go ahead? You started to flip to the next one.
Yeah, and I'm going to, one more comment here. You know, the one thing I hear a lot from HR professionals who are responsible for compliance is just tell me what the rules are and then we'll comply with them. And so it really, I was really impressed with the decision, like you talked about, is like all she's saying is you ought to have provided the regulated community with some rules, right? Whether it's the Trump rules, whether it was a different set of factors, whether it was fact sheet 13, you should have provided the public, the regulated public, with some rules that they can follow rather than just taking those Trump rules away and not replacing them. And I think a lot of our audience probably would say yay to that.
Right.
All right, so let's talk about it.
Best time. Go ahead.
Yeah. Yeah, and so those are and what I have on your screen, folks, is the three alternatives that the judge suggested the DOL could have done, but they didn't. But I think those are interesting because, and that really turns to what happens next, right? Because one of the things that DOL, Maury, could do next is they could just start the regulatory process all over again and follow the judge's decision to present some alternatives to the Trump regulations.
Right. But they would have to justify the alternatives. And I think it's, as I was alluding to earlier, it's not that simple for them to do. So that is one option. The other option is for them to appeal the decision to the Fifth Circuit Court of Appeals, where they've had some difficulties of late getting correct results, at least for them. They actually have been all too correct. They have ruled against the Biden administration on several prominent cases. So that can't be something they would look forward to, but they may think they have no choice. And somewhere in there, they could seek a stay of the decision, although if they were going to do that, it's kind of getting late in the game. They normally, if they're going to seek a stay, they ask for it right away. So, but appealing the decision is certainly one possibility. Starting the process over again is the other, or they could do both, which has been suggested as a possibility, but that's a little tricky to do. If they're appealing it and saying they don't have to do it, then they kind of undercut their own argument if that's what they do. So these are difficult decisions for them to make, and I'm glad they're the ones having to make the choice as to what to do now rather than us. We're going to certainly be ready to contest whichever way they go.
Right, it's both by commenting on any other regulatory process and, of course, defending the decision on appeal. So, Maury, what's the chances for the DOL on appeal in the Fifth Circuit?
Well, we should win, of course. I told, frankly, bet on outcomes of these things. I think the all I can say is the district court decision was very well reasoned, strong, and fully consistent with the authority out there. This what the Biden administration did was wrong, and if the Fifth Circuit sees that, then the Fifth Circuit rule against them. But I'm not on the courts. I just advocate, so we'll probably have to leave it at that place. But we think we have strong grounds for defending this judge's decision if they do choose to appeal it.
So, Maury, you won't say it, but I will. So the Fifth Circuit, it's like 11-5 Republican appointees. I know who appointed them doesn't matter, but as I recall, Maury, 6 of the judges on the 11th Circuit were appointed by Trump.
Okay. That's right. Now, we're talking about the fifth. He's got a solid group there, but you never can tell. That's why I mentioned the Obama judge who voted against the Obama overtime rule. So you can't tell, but it is a relatively favorable court for those who are challenging the Biden administration. Let's put it that way. And I think a difficult choice for them to have to appeal there.
And how long would an appeal, if they decided to appeal, Maury, how long would that take? Is that another year?
It's a very rough rule of thumb. They could seek expedited consideration, although I see no reason why the court should give it expedited consideration. I mentioned earlier they could seek a stay, but they have no irreparable harm to justify a stay. I mean, they'd have to argue that somehow it's bad for there to be greater uniformity and clarity. I think that's a hard sell. The briefing process in the courts, it ebbs and flows depending on how busy they are, but having argued in the Fifth Circuit before, 6 months to a year is a range that one could expect in a normal course type of litigation. And so that's in the meantime, in the absence of a stay, the Trump rule is in effect.
And that leads us to the question, and I see a couple of questions coming in from our audience. Yes, the Trump, this was Eastern District of Tennessee, so are the Trump regulations in effect everywhere, and will DOL follow them?
Yeah, they have not said. The Eastern District of Texas, the same court has in the past issued what's called a nationwide injunction. And what she did this time was she simply vacated the rule. Well, if it's vacated by a federal court, that can have nationwide effect. I think our position would be that it is nationwide. The plaintiffs, another factor in whether something is nationwide, is who are the plaintiffs. If you just had a local Texas company and that was it, there would be less reason to think it was nationwide in effect. But the plaintiffs here were national trade associations, were and are still active, national trade associations who have members all over the country who are dealing with this all over the country, and that does strongly argue for nationwide impact. These are all questions that may be fleshed out, and right now, the Department of Labor, all they've said about it is what you have on the screen here. Although I believe it also, they put the fact sheet number 13 underneath this statement, and even that is arguable because one could argue that the new guidance supersedes fact sheet number 13, but I know we're going to have a little more discussion about that issue. And the question, will the DOL follow the 2021 regulations? I'm itching to answer this question that was asked just a minute ago here about reports that the opinion letters, there are a couple of opinion letters that were issued in anticipation of the rule, and that were they reinstated by the ruling or not? They were withdrawn by the Biden administration on the grounds that they were premature because the rule had not gone into effect. This occurred even before they declared the rule withdrawn. That question has not really been answered, but I think the administration, until the administration acts to reinstate them, I think there is an argument that they could be reinstated, but in light of the rule coming out. But I don't think that the rule automatically, the court's decision automatically reinstates the opinion letters. Once we have a clearer view of, is there going to be an appeal or not, and what type of appeal are they going for, that could affect what happens to these opinion letters. Because if they haven't been reinstated, the question is, why not? And what's the justification for not reinstating them when they were good, common sense opinion letters that did anticipate the rule, which is now in effect? So why not reinstate them? But you can imagine that the Biden administration may have a different view about that. So this is something that has to be fleshed out going forward.
It does. Another thing I would say, because we've had withdrawals of opinion letters before, folks. So, if I'm litigating or if I'm defending a DOL investigation, you can, even though those withdrawn opinion letters do not have official status as giving you a good faith defense as an employer, they still can be persuasive to a court. Probably not the DOL, but if you're in court, a judge could read those opinion letters and say, well, they were applying this rule, which is being reinstated. I think they are well reasoned. So yeah, I'm going to follow those opinion letters, even though I'm not compelled to follow them by law. So yeah, I would definitely.
I think that also. Right, and I think, Tammy, that is probably the most significant impact of the court's decision reinstating the Trump rule, is that it is now, if you're in litigation over the independent contractor issue, you have another resource, another place to point your courts to. Whatever court's looking at your case, it should have persuasive authority, not only because it's an exhaustive analysis of all the court decisions in the last many years, but it is now the rule of the Department of Labor. So they're supposed to give it persuasive effect. And as long as it's in effect, then it becomes something that can be cited to by your attorneys in defending your pending cases right now. So that has value. It has immediate value right away.
All right. So one last question, Maury. I know you have to. You have another call you need to go on, so you have to exit soon. But I have one last question. So, as you know, on March 30th, the Senate voted 53 to 47 against President Biden's nominee for the Wage and Hour Administrator. Now, that was David Weil, folks. The picture's on your screen. And he had been confirmed and served in the position of Wage and Hour Administrator, and that was my old position at DOL in the Obama administration. So I was Wage and Hour Bush. David Weil came after me. He was Wage and Hour Administrator Obama, was nominated again, but then he couldn't get what we call cloture. So cloture is a vote on whether you're going to vote. And as I said, he lost 3 Democrats, Senators Manchin and then the 2 senators from Arizona, as I recall. And now the White House has formally withdrawn his nomination. That happened on April 7th. Now, while one of the reasons I think there was opposition to him was that he had been very vocal about his objections to independent contracting and franchising, and he calls it fissuring. His view is that contracting, franchising are the cause of exploitation of workers, including low wages. That leaves Jessica Lumen, currently the acting administrator, to run the agency, and she is supported by the Solicitor of Labor and Patricia Smith, who served as Solicitor of Labor in the Obama administration and is now senior counselor to Secretary Walsh. So and I'm sorry for the long question, Maury, what effect is the rejection of the Weil nomination likely to have on DOL's approach to independent contracting as we move forward into the next step? I mean, can we breathe a sigh of relief because David Weil, the enemy to independent contracting, is gone?
Well, yes, but not the other folks on the screen there, frankly, share his views. Jessica Lumen, who we've worked with, nice person. She is the one who spearheaded the whole effort to withdraw the Trump independent contractor rule without a confirmed wage hour administrator in place. She led the action and now is dealing with the consequences. The same with we have the former solicitor who's now senior counsel and the new solicitor. They've got their hands full, I think, because they also have a lot on their plate, self-inflicted, but they are trying to do yet another rewrite of the overtime rule. They're trying to do a massive rewrite of the Davis-Bacon prevailing wage rule for the construction industry, not to mention the occasional COVID business, as well as things like tip credit. I mean, the wage hour division just has a lot to do, and now they've got one more thing to do. Maybe they should take a break and just let these things percolate for a while. But no, I'm sure they have to. They're sitting there trying to make some tough decisions. As I said before, I'm glad it's them and not us. We'll just respond to whatever they wind up doing. And what happens to the administrator position itself is an interesting question that only the president and the secretary of labor know for sure, and probably don't know for sure what they're going to do next.
Yeah, I haven't heard anything. The only thing that scuttlebutt that I've heard is that some people think President Biden will go ahead and nominate Jessica Lumen to take that position. But the problem with nominating her, Maury, is then she cannot be acting administrator while her nominee to be administrator is pending. So they sort of lose her help on this and all the other efforts that you mentioned that they have ongoing.
Yes, and
I haven't heard any
today about violations of the Vacancies Act, not with regard to her, but with regard to another appointment who was in place at the Office of Management and Budget, and which the agency that approves these regulations apparently claimed that there was serving improperly for like 5 months. So they're very sensitive to right now, in particular, about following all the procedural rules for the appointment process, and how that plays out is just another problem they have to deal with.
Great. Yeah, under the Vacancy Act, to the listeners, because Weil's nomination was drawn on April 7th, so under the Vacancy Act, Jessica Lumen can only serve as acting administrator for 210 days from that April 7th withdrawal of the nomination. Maury, all great information. So wonderful to hear about you, about the litigation from you. So thank you so much for joining me today. I've learned a lot, and I'm sure that our audience has too. So thank you so much for joining us.
Sure thing, and good luck explaining to everybody how to comply going forward. So good luck there.
Yeah. Thank you. And before I move on, I'm going to answer one more question from our Q&A, and that is, if the Trump rule remains in effect through 2022 or maybe 2023, might a Republican Congress thwart DOL effort to change the rule? Can they stop a new regulation from occurring? And I have a little bit of experience about that, but way back in 2004, of course, you guys know I did the overtime rule as administrator of the DOL. And here's the thing. During our regulatory process in 2003 and 2004, there were a total of 11 votes to try to stop us and what we were doing in Congress. But they were never the same language on the same bill by both houses. So we basically ignored them, and we went on and did what we wanted to do. Because you literally need, in order to stop an agency, you need to control the White House and both houses of Congress to do that. So I don't think we'll see a legislative solution to this issue at all. So I know what you all are thinking at this point, and it's time to sort of change course a little bit. You just want me to tell you, what are you supposed to do? So here is my advice, and it's my advice, right? So you need to talk to your lawyer about it too, but just for what it's worth, I think that if you're defending your company in private litigation or in a DOL investigation, then you should argue that the 2021 regulations and those two opinion letters apply, that is the current law that the DOL is required to follow when enforcing the FLSA. But we need to be realistic, right? The DOL could win the appeal, or they could do new regulation, and if they do new regulation, it's not going to be like the Trump regulation. So if you're, as a policymaker, if you're trying to determine whether to allow a worker to be an independent contractor or whether you have to hire them, then I would suggest actually go ahead and following that fact sheet 13, which DOL has on its website. And don't worry, I'm going to tell you where it is. So that's the guidance currently posted on the DOL's misclassification website. And it is the It's what the DOL put up after they withdrew the Trump regulation. So if you're if you're being investigated, if you're already in litigation, your best argument is to argue that Trump regulation in those two opinion letters. But if you're not yet, if you haven't yet been sued or been visited by DOL, then probably the better part of valor is just to go ahead and make your decisions based on that fact sheet 13. Let's then talk about what all this stuff means, right? So I'm going to try to go over both the regulations and fact sheet 13 so you can understand what's in both. First, the regulations. Remember, as I said, it's the economic reality test with the two core factors for determining whether or not a worker is economically dependent on your company. So let's take a closer look at these two core factors. And I see we already had questions about what is the opportunity for profit or loss. What does that mean? Well, let me dig deeper into both of the core factors since you probably haven't really looked at it that close. So the control factor should be familiar with you because it's an important factor. It's an important factor under the IRS test, the 20-factor test you've probably heard about, and under many other state tests. And basically what that means is that if a worker can be an independent contractor if he or she exercises substantial control over key aspects of the performance of the work. Examples in the regulations are setting her own schedule, selecting his own projects, being able to work for others, including the company's competitors. It does not, the more, and here's the thing, under this test, the more you can, and this is not just this Trump test, it's NLRB, it's IRS, it's state laws, the more you control the work, the more risk you have that you have an employee rather than an independent contractor. And that last bullet point that's in the regulations, being able to work for others, you've heard this from me before, and do not have a non-compete agreement in your IC contracts, right? Because that will result in that person being an employee. So do not try to control how, when, or where the work is being performed by the worker in order to be an independent contractor. However, the Trump regulations did specifically say that control does not include if you require the worker to comply with specific legal obligations, satisfy health and safety standards, carry certain types of insurance, or meet contractually agreed upon deadlines, or even contractually agreed upon quality measures, right? So you're not going to review, an independent contractor doesn't get reviewed like an employee does, right? There's no performance reviews. But if you have quality standards in your contract, you can evaluate whether the contractor meets those quality standards. So this is great stuff. I don't think it's anything really new for somebody who's dealing with independent contractors for a long time, and it's very familiar and similar to what we have under other state and federal laws. More difficult, I think, is that second core factor, the opportunity for profit or loss. Now this is from these regulations, okay? The worker must have an opportunity to earn profits or incur losses based on the exercise of managerial skill or business judgment, or by managing her investment or capital expenditures. For example, if the cost of required equipment and a low bid combined causes the worker to take a loss on the contract, right? Maybe they spend too much on equipment and they should have had a higher bid, so they're going to take a loss on the contract. That's the opportunity for profit or loss. On the other hand, for example, if they subcontract the work out to a lower cost employee and thus they can make more money, that's also an opportunity for profit and loss. But perhaps the best way to understand this factor is, and this is straight from the regulations, is that workers who are unable to affect earnings at all, or they are only able to earn more money by working more hours or working faster, so efficiency or hours, that person is an employee. So if you're paying a worker by the hour, for example, and so the only way they can make more money is to work more hours, that person is going to be considered an employee. Whatever DOL, who's ever running the DOL. So that's the opportunity for profit and loss. One of the things here I think is another good example is don't pay business expenses. Because if you do, then there's there's no opportunity to take a loss because you spend too much on business expenses, for example. The other core factors that are listed in the regulations, and these core factors, DOL said that they're only going to look at them if these three other factors, if the two core factors point in opposite directions. So if the two core factors, control and opportunity for profit and loss, point in the same direction, you're not even going to get here. But what I've put here on the screen is the three other factors, the remaining three factors, and how the regulations define what these mean. So the amount of skill. The work that is being done requires specialized training or skill that the potential employer does not provide. So here, janitorial companies, your cleaning ladies in a retail business, that's not a specialized skill. So that factor would point against you. Second, the degree of permanence of the relationship. Now, this is something you've all heard before. The work relationship must be, by design, definite in duration or sporadic. So that may include regularly occurring fixed periods of work, although if it's a seasonal nature of work, and that's all it is, it's not going to indicate independent contractor status. A lot of companies have, because of this factor, have limited the how long an independent contractor can work for them. Some say a year. It's really artificial, right? There's no black and white number. But again, think about this. The longer you've had a relationship with a particular independent contractor, the more risk you have that somebody's going to find that contractor to be an employee. One of my I was working for a client, and they had a worker who had been working their security for 11 years, right? You're not going to win that case because 11 years is like way too long. Finally, whether the work is part of an integrated unit of production. I hate this factor and argued with DOL that they should drop it entirely, but they didn't. But they actually did make it a little bit different than what's in Fact Sheet 13. What it means is that the work is segregable, can be separated from the potential employer's main production process. So it's different from the concept of the importance or centrality of an employer's work to the potential employer's business. So when gig companies were losing cases, when they lost cases, a lot of it is because, like the driver is essential to the gig company's business because the big gig company's business is hooking up passenger to driver. But that's not what this is about. What they want to find out is whether or not the work that is being performed can be separated and is different from the employer's main production processes for their business. So those are the regulations. And if you want to know, I do have more on, I have my February, maybe. Anyway, on ComplianceHR, you can find another webinar I've done that have detailed analysis of these types of factors and what you should do. I have my green flags and red flags, and also in a Tammy talk, so you can go back and view those and learn a little bit more about that. But those are the regulations which the Texas court did find are in effect today. But equally important for you is the guidance currently on the DOL's, what they call their misclassification website. And the address is on your screen, dol.gov/agency/WHD/FLSA/misclassification. Now, at the top of the website is a nice chart comparing employees and independent contractors. Yeah, and you heard me right. I like this chart. Because a lot of what is on here is familiar, similar to the slides that you can see in my prior presentations and my red flags and green flags. I have been saying a lot of the things that are on here since 2015. So, for example, an employee is somebody who works for you versus running their own business. An employee is paid hourly, salary, or piece rate. An independent contractor is paid on the completion of the project. I don't have time to read through this all the way through, but you can study it. And please, this everything that DOL, the current leadership of DOL thinks about independent contracting is on this website, right? So as I said, it's something that you should read, you should pay attention to, even though, a litigator like Maury would say, oh no, it's the 2021 Trump regulations. Still, read this. And if you follow what's on this website, I think you won't get sued. It's unlikely that you'll get sued. A couple other really cool things on this website is a little page that says the myths about misclassifications. Now, the purpose of this page is to convince independent contractors that they really are your employees, but they all reflect the current DOL's views and is definitely worth a read. Also on this site is a page called Get the Facts on Misclassification. Also there's a little video, like a 5-minute video linked here that's called a Know Your Rights video. Again, these are trying to make workers understand that they're really employees and not independent contractors. That's the tone and the audience, but it's well worth you spending time on the website and doing the read. On this website is also where you can get a link to Fact Sheet 13. This lists Fact Sheet 13, don't forget what we said, this is what DOL posted after they had withdrawn the Trump regulations, and it includes a 7-factor test that DOL says it considers when under the economic reality test. Now, many would argue that this test is gone because it's contrary to the Trump test. But please go ahead and read it, because you should at least know what's in here and try to judge your practices against this. We'll give you just more information when you're trying to make decisions. So the Trump DOL took this fact sheet off the DOL website, but then the Biden administration reposted it after the regulations were rescinded. Now, last month, the DOL revised the fact sheet by adding that notice about the Texas court decision. There's the 7 factors. They're on your screen. I don't have time to go through them all today because I see I'm at 51 minutes, but basically, briefly, integral part of the principal's business, the permanency of the relationship, the investment that the contractor makes in facilities and equipment, the nature and degree of control, the opportunity for profit and loss, the amount of initiative, judgment, and foresight in the open market competition with others, and the degree of the independent business organizations and operations. Now, this fact sheet 13 just lists those 7 factors without much else in them. There is, however, a withdrawn administrator's interpretation that was written in 2015 by David Weil, and in just a few slides, I'm going to show you how to get that administration interpretation. Now, it's withdrawn, just like the opinion letters the Trump opinion letters are withdrawn, but it is the opinion of David Weil, and thus and the Obama administration folks who are back at DOL. About how to apply these 7 factors. It's called Administrator's Interpretation 2015-1, and it is something that you should also go and look at and read to learn more about what the current leadership at DOL thinks about these factors. And in fact, they could use that Administrator's Interpretation plus this Fact Sheet 13, and there you go. They have a new proposed regulations that they could put out for comment. Which I think is the quickest way to get where they want to go, but they won't listen to my advice. All right, we're coming up towards there it is. Okay, so there is the URL for you. You can't actually find the Trump regulation on DOL's website. They haven't put it. They've just that little notice is all they put back up. But you can go to regulations.gov, and I've put specific URL so you can pull up the Federal Register notice that has the actual regulations in it. On the other side, the Biden and Obama guidance, fact sheet 13, plus that administrator's interpretation 2015-1. If you read those two pieces of those 2 guidances and you try to follow those when you're determining whether or not to classify a worker as an employee or an independent contractor, you're going to be in pretty safe territory. So that's the conservative option. The following the regulations, I think, is the best option for litigation, and but it's a little bit risky. It's a little bit risky because we still don't know what's going to happen in that litigation. All right, so we've spent our time today talking about the chaos that is the independent contractor compliance under the Federal Fair Labor Standards Act, right? One law and it's chaos because you don't know what to follow. Should I follow the regulations? Should I follow Section 13? I don't know. But that's just the beginning, as Maury mentioned, and not the end of the chaos, because when making the IC determination, you must consider all the federal tests. And there's more than just the FLSA economic reality test. There's the IRS 20-factor test, and then there's that Darden common law test that's applied by the EEOC. It's applied by the NLRB. That's from a Supreme Court case. And then, of course, you have the state laws. And all the state laws that apply. Under state law, states can have different tests under different laws. So the independent contractor test under the wage and hour law, just like under the federal law, can be different from the state tax law or the state unemployment law or workers' comp law. So I have actually done the job. I've counted them up. And there are more than 100 different federal and state statutes with tests for independent contractor status. Now, these lists that I put on the little pictures of the pages that I put on the screen are from an appendix to a paper I co-wrote for the Chamber of Commerce. And you can find these lists if you just Google McCutchen, Chamber, and gig, and you can pull it right up. So whether you're auditing your current classifications, and you should, or reviewing a new independent contractor, you need help, right, to ensure that you're applying the right law and are gathering the right facts to reach a conclusion that can be defended in court or with the DOL. Now, I personally know of only one way to do that without spending thousands of dollars on outside attorneys, and that, of course, it's my app. Okay, that's that Navigator IC application, which currently has Fact Sheet 13, the IRS 20-factor test. All the state tests are incorporated into the analysis that this app does for you. And I'm going to turn it back over here just briefly to Kimball so he can tell you more about the Navigator Independent Contractor app.
Yeah, well, thanks, Tammy. It's a lot of information, and we're here to sort it all out for you. So yes, the Navigator Independent Contractor tool is an expert system that helps users to really determine the employee or independent contractor status. It's drawing from a proprietary engine, really an evergreen database that we're constantly adding expert content to. Currently, over 1,900 reported court decisions and DOL opinion letters factor into determinations. We analyze the individual fact patterns that users put in under all applicable federal and state regs, and then it delivers an actionable risk assessment along with a report on how to lower the risk of misclassification, a summary of applicable laws, and a transcript of the questionnaire answers that were put in. Not to do a demo, but a couple very simple questionnaire-driven input to the application. Very easy to use. And what do you get out of it? You get an example, or here's an example of what you get out of the app. In just a couple seconds after you submit your questionnaire, the app provides an overall risk level and risks by jurisdiction. And what you do with that result will obviously depend on your company's risk tolerance and expert advice from counsel, but in addition, the app also generates a memo on what you can do to lower your risk. So it actually goes through the various factors and offers some guidance on potential strategies you can take to lower the risk of independent contractor misclassification. Again, if you'd like a demo or a free trial of the app, just go to the URL at the bottom of the screen or click the button on the right, or let us know in the Q&A box. And as a reminder, I know it's come up in the Q&A here, we will be sending out the slide deck and a link to the recording of this, so you'll have access to all this after the fact. Now,
so Kimball, I've had some time, Kimball, to look through the questions, and I think we have some time to answer a couple of them. I will one more thing about the app, folks. So what the app does is you put in the state where you are trying to evaluate, and the app itself identifies the most difficult test under federal law and the most difficult test under state law. For federal law, that is that economic reality test, and then applies that law to the facts you input into those questionnaires, so you know what you're getting is an answer that would be my answer if I was looking and trying to classify your worker. All right, couple quick questions, and maybe if we go a little bit over, you guys can stay on with us. So can you discuss the applicability of ban-the-box laws to independent contractors? So that's a state law issue, right, because the ban-the-box laws are state laws. And it depends upon whether the ban-the-box law is written to cover just employees or independent contractors. And my instinct, but you'll have to go back and look at it, is most ban-the-box laws address employees only, and then therefore wouldn't be applicable to independent contractors at all. Scrolling down a little bit more, is there a particular time, this is about that duration factor, an employee should wait to work with an independent contractor who was once an employee? I love this question because my answer is never, ever hire an employee as an independent contractor. That's one of my big 5 red flags. It is going to walk you into a misclassification case. So I'm sorry. You know, you have you just don't do it unless, and I would say the only exception is an employee who went out and started his own business and had a lot of customers, right? And you're just one of them. But if you have an employee and you're the employee's first and only customer as an independent contractor, you're going to lose that case. So just don't do it. So I think a lot of these I hit actually. Let's see. Examples of business expenses. This is a good question. So the biggest one that a lot of people reimburse is travel expenses. And I know it's really tough, but an independent contractor, has to just incorporate that into their pricing, right? So any type of business expenses, whether that be computers, whether that be travel, whether that be office space, nothing that any business would have to incur on their own should be reimbursed. All right, I think we're a little bit over. Folks, what's going to happen now is you've asked some really good questions. We haven't been able to, one more, and then everybody else's questions, I'm going to get an Excel spreadsheet with them, and I'm going to answer them. So you will get answers to every single question we add. But this last one, I think, is a very good one to answer for all of you. If the IC really wants to remain an IC, what is the risk as an employer and IC for us to keep them as an IC? What is the risk? Well, I've run into this a couple times, guys, because I did some work for a company who was actually a Department of Defense contractor, and they had some ICs that were former military, and the ICs basically said, I don't want to be an employee, and if you make me an employee, I'm going to go work for somebody else, and then the contract with DOD is going to go with me. And so it really puts you between a rock and a hard place. But just know that there is risk. Now, if you're talking about a senior, one or two people who are very senior, very skilled, and they want to remain your independent contractor for a long time, I think the risk is fairly low. So it's something that's what is your risk, right? Your risk, though, is overtime. Your risk is premiums for your unemployment insurance, for your workers' comp insurance. It's employment tax that wasn't paid. So think about your risk and think about how important it is to your business to keep this worker as an IC when it looks really, really difficult to reclassify, and that's got to be an individual decision. Well, thank you so much, everybody. And Kimball, I think that's all I can do in our time today, but I will get back and answer more questions.
Much. Yeah, thank you so much, Tammy, and everyone for joining us. Again, if you have a moment and any interest, please do sign up for the demo and free trial. We're happy to share our knowledge and expertise and hopefully provide value to all of you. And thank you all for joining us today. And with that, I think we're wrapped up.